But this is the thing. They're giving the illusion that we've got to do what they say. It's the other way around. The Constitution is a restraint on government and what they can do. So that's why they are ignoring it. It's their restraint. They cannot make laws telling us what our children watch, listen to, etc. So this is an absolute gross overreach, and once again, this has become a very common denominator in what government are trying to do. They're giving the illusion that they have some kind of authority to tell our children what to do. No, they don't. That is up to the parents, not government. The bottom line with the Digital ID Act and the Online Safety Act, there is no head of power under the Constitution for them to create acts that restrict us, tell us or our children, because we're in charge of our children, not the government, what we can watch, what we can listen to, what we can think. So this is absolutely ultra-vires. And you'll find this is quite a common theme that is occurring. Government trying to make all of these acts and legislation saying you can't wear this, you can't wear that, you can't act in this way, you can't do these, symbols with your hands, etc., etc. It's all utter rubbish. We have an implied freedom of political communication, and they cannot stop us speaking out. They cannot stop us what we think, what we listen to, or anything else. And, you've got the Crimes Act that is in place. If you were to incite violence, that, through your actions or speaking, that's a crime. So you can't do that. So basically we can do anything we want, providing we are not inciting violence or defaming someone. And if you do that, the Crimes Act will deal with you because that's committing a crime. But as I said, there is no head of power. The Constitution is the supreme written law of our nation. And any act, statute, legislation that either the Commonwealth or state parliaments create are subject to the Constitution. So they must have a traceable source of legislative authority back to the Constitution, in particular to the enumerated heads of power under Section 51 of the Constitution, which covers all the subject matter to which they can make laws. But it's also important to note that the Constitution cannot use the law, Parliament, to prohibit or forbid us from doing anything. They can regulate certain things such as road safety, speed limits, for example, but they cannot prohibit or forbid us to do anything.
So therefore, the only remedy that we actually have is to be able to get something into the High Court. So why are they blocking our access to the courts? Because that's where we can get remedy.
Yes, that's right. Because the whole show will come falling down around them. Humanity is under attack, and we must all link arms together as brothers and sisters and stand up lawfully and peacefully always. They need to have faith that the Constitution protects them. Yes. Will protect them. It is a restraint on government. People need to recognise government are our servant, and they need to be put back in their place.
Welcome back to Health Alliance Australia's podcast. My name is Jeannie Rose Angebartha, and today we have Jacquie Dundee with us, who is a well-read on constitutional law. You must have seen Jacquie around. She's fearless and outspoken on political corruption. Thank you so much for coming today, Jacquie. Would you like to tell you a little bit about yourself?
I'm a mother and a grandmother. I started studying or learning the Constitution from Darryl O'Brien with the Community Law Resources Association probably about 25 years ago. 25 years plus. And in the last 5 years, been really studying and concentrating on not just the Constitution, but the High Court precedents that have been set, because they are the ones that interpret the Constitution.
Yeah. So would you like, I think people don't quite understand why the Constitution is so important for us to understand. Like you were saying at the start, we all have rights, yeah, under the Constitution. And often it's been put out there that we don't have a Bill of Rights, therefore, you know, they can do whatever they want. And so we've seen a lot of this tyranny come along in Australia. But you're actually saying that we do have rights, and that you've gone
Absolutely.
through all these case laws, and that if you can get the case into the High Court, you're saying that they've never ruled against the Constitution.
Not to the best of my knowledge, no. And if anyone can come up with a case, I'd be interested.
Hmm.
They've
So can
always
you just
upheld it.
explain to us about the Constitution, why it's important for people to understand?
Well, the Constitution is the supreme written law of our nation, and any act, statute, legislation that either the Commonwealth or state parliaments create are subject to the Constitution. So they must have a traceable source of legislative authority back to the Constitution, in particular to the enumerated heads of power under Section 51 of the Constitution, which covers all the subject matter to which they can make laws. But it's also important to note that the Constitution cannot use the law, Parliament, to prohibit or forbid us from doing anything. They can regulate certain things, such as road safety, speed limits, for example, but they cannot prohibit or forbid us to do anything. And the Constitution is a restraint on government and what they can do. So that's why they are ignoring it. It's their restraint.
So in a lot of ways, what we're seeing right now is politicians act as though they are the supreme leaders of this land, and they are above the Constitution and they're not answerable to it.
Yes, and that's the exact opposite. Everything is inverted at the moment. So this is the thing. Government, Parliament are nothing but agents, administrators, trustees, and servant to the people. We, the people, are the Commonwealth, and we are the supreme and uncontrollable authority. And you can find that reference in the Quick and Garran, which is the annotated version of the Constitution. You can find that through case law as well. But this is the thing. They're giving the illusion that we've got to do what they say. It's the other way around.
And it's also the illusion, I guess, that you have to have a lawyer in order to go to court.
Well, yes, well, one of the reasons for that, of course, is because all the lawyers, solicitors, QCs, barristers, etc., they have all sworn their oaths to the bar and the state. So you will never find a qualified legal practitioner that is going to go against the state or the Commonwealth, because they'll have their licence taken off them.
Yeah,
And yeah, you hear them in court saying, if it pleases Your Honour. We don't care if it pleases Your Honour or not. We demand justice. It's a game. It's an absolute circus, what we're witnessing at the moment.
Yeah, I mean, I remember, I can't remember his name, from J&B Lawyers. Was it Nathan Buckley? That lawyer? No, maybe it wasn't someone. I can't remember his name, but he was struck off because he had brought a case up to say that that committee or that the government had set up with the Prime Minister was not legal under the Constitution, and that they had to produce the Freedom of Information documents. And now he seems to have vanished. And we also know Serene Tefel, shout out to her, Tefar. She has been very outspoken, and she's also had her license taken. So there is examples for exactly what you're saying, and the fear of non-compliance, the same as what's happened to doctors, that if they don't comply, that APRA, which is actually a private organisation or company, will strike them off.
Yeah, they're a statutory corporation. And this is why we have one of the reasons, just one of the many reasons why our government is unconstitutional. The Constitution does not recognise political parties, and it does not recognise government as a corporation. They cannot corporatise themselves. And we've got in writing from APRA that they are a statutory corporation. They are not a limb of government at all, which then brings to question, if you are a corporation, how can you be administering law under the national law, which is an act of Queensland? Look, there is so much deceit and so much illusion, and the whole game plan is to run people through the courts, award costs against them so it stops you from appealing up to the higher courts. It's just an absolute mess of collusion, corruption and perverting the course of justice. And, you know, really, when you look at the lower courts in particular, they're nothing but star chambers. And we've got these magistrates and judges that are sitting there in what's called persona designata, which means they're not sitting in a judicial capacity. They are sitting there in their own private capacity, basically laying out their decisions based on their opinion for the day. We need, you know, judges must be judge operating in a judicial capacity. The whole thing's absolutely twisted. We're in trouble.
Yeah, and I think what we're trying to do, with, as I said you at the start of this, that we would try and link together all the things that are, or many of the things that are actually happening right now that people have concerns about. So I thought we'd start off with the under 16 social media ban. And many of us will say, yes, we know that this is all to bring in some form of digital ID to attach our identity to the online space, which is very dangerous. And we've seen what will happen what's happening overseas too. But you've got a writ that was sent to me about that. Could you tell us a little bit more about what?
I'll tell you a little bit about it, but I'm not going to get everything out at the moment because we've got something happening underway at the moment.
Yeah, that's okay. I think what I'd like to show people is that you are people, Australians, who are taking this as private citizens, is that right, to the High Court?
Yes.
You haven't got a lawyer representing you?
No lawyers. We have nothing to do with lawyers.
Completely self-funded.
Nothing to do with anyone in the legal fraternity. They cannot be trusted. So we've got a bank account set up, the Community Law Resources, which originated from the Community Law Resources Association, for people to donate into. So for plaintiffs, so those that are happy to or offering to stand up for all Australians and ensure that our Constitution is upheld. That's what this funding is for, to ensure that they're not financially crippled, you know, and that Australians are behind them, and that's the best thing that they can do. So you've got lodgement fees, and then each time you lose in a lower court to appeal up, it's more costs, etc. And this is what they are relying on, financially crippling people so they can't keep going up through the court system. So, you know what I say, the only way to control the executive and the legislative branches of government is with judicial force. Now you've got, you know, you've got the three separation of powers, and they must remain entirely separate from each other. But we're not seeing that at state level, that's for sure. It's just a mass of collusion and corruption.
I think people, we haven't seen it for a long time where a court has been able to, I don't know the last case where a court was able to strike out a law, but I'm sure there's probably lots of examples where the court system could say to the government, hey, by the way, this goes against the Constitution, and we think it's illegal or unlawful.
God, I've got a blank now. What the court has done in the past is they have invalidated acts whether that be the whole act or whether that be just in part. So they'll take out the sections that are unconstitutional. So they will do that. They're happy to do that than attack an individual. And, really, the High Court is for constitutional matters and that pertaining to federal law as a general rule. So
that's what you're trying to do here, is that right? Like, you're trying to
correct.
take a case, and because they've created this piece of fiction, an act, and put it out there, and you're trying to have it. Essentially, you would expect, in a perfect world, you would expect the Senate to review a law and look and see if it's according to
constitutional.
Right? It's constitutional, right? But what we're seeing at the moment is laws are being passed that are not constitutional. And in order to, and of course, the Governor General also has the ability to not give royal assent to any of these laws. But this is not being done. So therefore, the only remedy that we actually have is to be able to get something into the High Court. Now, this has been the little bit of an adventure, hasn't it, to be able to get heard.
Yeah,
so if you want to just talk about that as well as the case, so gives people an idea of what we're actually up against and why, like, give them some hope that this is the remedy that we're going to try and achieve.
Look, other than going through the court system, it's imperative that the people we need to unite together and focus on the courts so they know we are watching them. So that's why it's very important for people to attend the court cases when they can, so where they're in numbers, or to watch remotely, because we must keep them accountable. This is the thing. So look, I'll do a very brief overview of the Online Safety Act. Now, we lodged that in the High Court to begin with, and they rejected it. So we thought, okay, then we've put it into the federal court, which they've got no jurisdiction to hear the matter, and we know that, but it's to try and get it up through appellate rights. Now, the bottom line with the Digital ID Act and the Online Safety Act, there is no head of power under the Constitution for them to create acts that restrict us, tell us or our children, because we're in charge of our children, not the government, what we can watch, what we can listen to, what we can think. So this is absolutely ultra vires. And you'll find this is quite a common theme that is occurring. Government trying to make all of these acts and legislation saying you can't wear this, you can't wear that, you can't act in this way, you can't do these, symbols with your hands, etc., etc. It's all utter rubbish. We have an implied freedom of political communication, and they cannot stop us speaking out. They cannot stop us what we think, what we listen to, or anything else. And, you've got the Crimes Act that is in place. If you were to incite violence, that, through your actions or speaking, that's a crime. So you can't do that. So basically we can do anything we want, providing we are not inciting violence or defaming someone. And if you do that, the Crimes Act will deal with you because that's committing a crime. But as I said, there is no head of power. Telegraph and telecommunications were removed from Section 51 of the Constitution, which gives concurrent powers to both state and Commonwealth Parliament to make laws on that subject matter, except for those that under Section 69 were at a time the Commonwealth chose. They were to then make those powers exclusive to the Commonwealth. Now, everything under Section 69, this is interesting, other than the quarantine power, has been made exclusive to the Commonwealth. So, telegraph and telecommunications, the Commonwealth can make laws, which of course is online, etc. They can make laws pertaining to that. They can make regulatory laws for the providers of the services. They can create laws pertaining to the infrastructure.
Yeah.
But they cannot make laws telling us what our children watch, listen to, etc. So this is an absolute gross overreach, and once again, this has become a very common denominator in what government are trying to do. They're giving the illusion that they have some kind of authority to tell our children what to do. No, they don't. That is up to the parents, not government. So you look at it this way. The only time that the government could have a say over our children, what they're watching or listening to, for example, is when they are in school. Okay, so they're in the public system, they're in school. They can tell them to lock their phones up in their lockers, for example. But of course, the schools are now filled with computers and tablets and everything else. So how would they put a stop on children, looking up on computers or electronic devices, things that they don't want them to see? They put blocks on them. Now, that is exactly what parents can do at home. And as we are all very, very well aware that this is nothing but trying to control us and get everything under digital ID, etc. It is it really is abhorrent what they are doing. And you've got to look at what they've done. They're doing the same principle here, okay? So what they did with COVID and mandating jab, they did indirectly here also what they couldn't do directly. So the government couldn't force you to undergo a medical service. I mean, the irony of it, and it was an experiment, which I don't believe it was. I believe they knew what it was going to do regardless. They threatened employers. I think it was a $35,000 fine per employee if that employer did not see or if they didn't collect up the vaccination certificate from their employee. Now, the government's not allowed to do that, and there's a lot of case law on that as well. You cannot force somebody to do something that they may lawfully decline to do, but to do so would remove their livelihood. Like, that in itself would breach the doctor-patient relationship. So this is the other thing. Anybody that went to their doctors that made it clear to them that they didn't want to get the vaccination, but they were going to lose their job if they didn't, they were under undue influence, fear, duress, coercion. And the doctor-patient relationship is a contract in law that no third party has any obligations or can intervene in. So it's all just, it's unconscionable what they've done. It's malfeasance is what they've done. It's
And
hard
they
to believe.
destroyed the evidence afterwards because when
Yeah, I know.
it was completely set up. And I noticed during the whole COVID thing that no one was signing any of these letters that were going out. That this was the ones that I saw. No one was personally putting their name to it, and they were even, distributing these notices through unions and various things that, oh, you have to do this, and then they made an announcement, and everyone was just glued to the screen, believing that anything
Yes.
that Brett Sutton said was like the word of God, literally, and it was somehow law. And all of a sudden, I remember the announcement was made, and literally within that day, or maybe it was like 24 hours later, my sons had a letter in their hand from their employer saying that mandating them to take the vaccine. And I thought to myself, how could they possibly have consulted any lawyers or done any due diligence at all? But they all fell for the psychops, which is that the government has the right to tell you what to do. Now, I sort of wonder, how far will they push it? Will they say to you, you must have meatless Mondays and fish on Fridays? I mean, how far will people allow the government to dictate to them their lives? So we've seen them push the fact that they could lock people up coming into this country that didn't have COVID. I mean, didn't test positive. They weren't sick. They could lock them up in a hotel for 14 days. People weren't allowed to see loved ones as they were dying, testing or no testing. Now they're told that if you don't, the same way that what you're saying, they're told that if you don't get a certain number of vaccinations for your children or your babies,
Yes.
you're not allowed to enroll them into early childhood education, and you're also not eligible for childcare rebate or what else was there? Well, you're not able. I think in Queensland actually they don't have no jab, no play, because again this is a state issue, access to these centres, but everywhere else if they manage to around the states produce this no jab, no play, and then so what happens is people get to their childcare centre and they say, oh, I want to enroll. And of course, they always have a loophole. So one of the loopholes that they put in was the, what was it? The 16-week grace period if you were in certain vulnerable groups. So I don't know if you know this, but if you're Aboriginal and Torres Strait Islander, if you have a healthcare card, or you had any contact with the system, then you can be put on a catch-up schedule. And but the thing about the legislation, which is quite interesting, is that no one actually checks if you actually did anything at the end of that 16-week grace period. And if nothing happened, well, you can get to stay in the centre. But the penalty, I guess, is you won't get the federal funding for the rebate, and it's so expensive for people to access that.
And that's not mandating something, though. You see, that's an incentive, shall we say, and that's where, look, I love the work that I can't think of their names now, that the ladies that drive around with the bus informing people about the vaccines. I can't think of their name now, but the Vax bus. But what they did was they started to prepare a case that didn't end up going through. And look, I spoke to Meryl about this, but because I'm not a lawyer, she wouldn't listen to me. What they were doing is they were going to try and go in and invalidate a section, or they were challenging the section of an act, and that act was only pertained to receiving an incentive to get vaccinated. They should have gone after the Public Health and Wellbeing Act that mandates it.
Yes.
You either get it or you don't. But look, shall I go straight into Dr. Beverley's?
Yeah, sure. That's a good case to segue into.
Yeah, seeing as we're on that. So the thing is, so within the workplace, this is a clear, very,
so with Beverley's
very
case, she's got a case, right, in front of, it's been heard in front of the Supreme Court, High Court.
Well, it is at the moment. I'll give you as quick a rundown as I can on it. So we set a precedent in Australia's history, actually, because it was the first time in Australia's history that lay people have had a case filed in the High Court, and that they presented it in front of the justice by themselves. So Dr. Beverley's matter goes under Section 109 of the Constitution. So this is, if a law of the state is inconsistent with the law of the Commonwealth, the latter shall prevail. So in this case, the Fair Work Act 2009, a Commonwealth Act, and the latter, to the extent of the inconsistency, would be invalid. Now, every one of the health acts across our nation, this is where you've got to look at an act. How it is written is what's called in form. How it is actually used in its general application is how it affects us. That is the substance. So the Fair Work Act 2009, a federal act, a Commonwealth Act, clearly states at Section 26 that this act is to the exclusion of any state industrial law. Now, this is where there's a little bit of trickery going on here, because you'll find in section 26(2) of the Fair Work Act, I've got it copied out here. So, Fair Work Act excludes state or territory industrial laws. This act is intended to apply to the exclusion of all state or territory industrial laws, insofar as they would otherwise apply in relation to a national system employee or a national system employer. So, if your corporation or company meets the definition of a trading or foreign trading corporation within the meaning of section 5120 of the Constitution, which nearly every single corporation and company does, they have to adhere to the Fair Work Act. So then you've got section 26(2), where it says, it gives the definition: a state or territory industrial law is a general state industrial law or an act of a state or territory that applies to employment generally and has one or more of the following as its main purpose, or one or more of its main purposes. Number one, that qualifies the State Health Acts as a state industrial law, is that they provided terms and conditions in the workplace. That means they are a state industrial law. Another one is for providing and making the enforcement of agreements between and determining terms and conditions of employment. That's exactly what the Health Acts did. Prohibiting conduct related to a person's membership, providing for rights and remedies. Like, these state and territory acts across the nation all meet the definition of a state industrial law. So when the courts are looking at a Section 109 matter, they look at whether the State Act is directly or indirectly inconsistent with the Commonwealth Act, a federal act. Now, these state and territory health acts across the nation fit both. So, because it's written in the Act, the Commonwealth have clearly evinced their intention. The Fair Work Act is to the exclusion of any state act. The federal act is king and must be adhered to. That is an indirect inconsistency. A direct inconsistency would be if a state act alters, impairs or detracts from the operation of a federal act. So they stop the operation of the federal act altogether, because you weren't allowed to go to work unless you met the qualifications set out in the State Act. So it's a very, very clear-cut case. So
she was sacked from her work, is that right?
Yes, she was, because she wouldn't provide a vaccination certificate. So this is the thing. The matters were accepted, filed into the High Court, and a directions hearing for both Rod Culleton and Beverly Peir's matters were heard on the 9th of April of this year in the High Court. Now, the justice that heard the matters were Justice Beach Jones, the newest addition to the High Court justices from the Supreme Court of New South Wales. And he was the one that was on the Kazam versus Hazard matter, which was just another one of those matters that was designed to fail. So the media falsely reported on it. But both Dr. Beverly Peir and Rod provided very sound, solid, the cases are irrefutable. And not only did they present the cases, they gave Justice Beach Jones the grounds on which their matters should not be remitted to a lower court. Well, Justice Beach Jones, coming from the Supreme Court, if you want to give him any grace, has got no idea about the territorial operation of the federal court. and he remitted both of their matters to the federal court, a lower court.
Mm.
Now, the federal courts can hear constitutional matters, and they can also hear matters pertaining to federal or Commonwealth acts. So, but they do not have territorial operation, which means they do not have the jurisdiction to invalidate in whole or in part any state or Commonwealth act.
Yeah.
They can't do that because that would mean that they're at a high court status. So because he remitted their matters to the federal court, there was a challenge to jurisdiction that was put into the High Court with and also requesting an interlocutory injunction, meaning the federal court could not hear the matter until the High Court has determined the jurisdictional limit of the federal court. Can the federal court provide either Rod or Dr. Beverley the remedy they seek, which is to invalidate in whole or in part sections of the state acts? No, they can't. But we need the High Court to make that determination. So those applications were put in. Now, the rejection came back from the High Court through High Court Registrar Adam Griffith. Now, what's occurring, this is commonly occurring now in the courts with the judges as well. When you make a determination or a rejection in this case, you must provide intelligible and justifiable grounds. You must show the reasons, the grounds. Why did you come to that decision to reject it? And under the High Court rule that he used, 6.071, that is that upon the face of it, he looked over it and he thought that it was ill-conceived or frivolous. Nothing could be further from the truth. And this is a jurisdictional challenge, absolutely crucial. And then you've got the maxim in law, of course. Jurisdiction, once challenged, cannot be assumed. It must be proven. And it is a threshold issue. Because if you fail in one element of jurisdiction, the whole case is out the door. So Adam Griffiths, in his rejection, wrote the High Court rule number 6.07.1. It's like, hold on a minute. So not only did he not provide any grounds for his reasoning, the second protocol that must be adhered to with that High Court rule is that he must contact the applicants and have a discussion with them, give them the opportunity to respond. He did neither. So then thought, all right, well, he's not following due process, the correct process in law. So he was then sued. So then sued Adam Griffith, said, you're not doing your job, you are perverting the course of justice. That matter was also rejected by his colleague, Anna Bennett, another High Court registrar, Commonwealth public official. So her rejection was given on the grounds of 6.072, saying that we needed to seek leave of a justice. And we thought, hold on a minute, how can you get to 6.072 prior to using 6.071? Don't think you can. So we emailed her and asked her the question. And she came back with, oh, well, yes, I actually did use that. Bang. You perverted the course of justice, and what you are doing is obstructing the people's access into the High Court. That is a crime. So the Supreme Court of Rodney and Beverley did not consent to the jurisdiction of either the Victorian Supreme Court or the Western Australian Supreme Court, and they're in this together. The cases have been joined. But they did agree to have it heard in the New South Wales Supreme Court. Hence, it is in there. So the Supreme Court of New South Wales accepted the matter, It gave us a filing, the file number, etc. And then I don't know what happened, but all of a sudden they changed their mind. And they sent an email saying, oh, sorry, we don't have the jurisdiction to hear this case. So an email was sent to the Supreme Court of New South Wales showing them, yeah, you do. You do have jurisdiction. So kudos to the Supreme Court of New South Wales. Within 24 hours, they reinstated the case with the same case number. So the first directions hearing was heard on the, I'm losing track of the days now, 14th of November, I think it was. Friday the 14th of November. And it was very interesting that at that hearing, we didn't even have a justice. We had a registrar. Rod and Beverly had a registrar hearing the matter. Like, this is crazy stuff. And the government solicitor attorneys general, the government solicitor general, the one who does all the legal stuff, tried to make a deal with Rod. And Rod said, no deal. But he does have in his hands paperwork now from the Commonwealth and state attorneys general saying that they may intervene in the matter. Now, that's very, very interesting. Why? And keep in mind, whenever you see may written somewhere, it also means may not. So the question then is to the Commonwealth Attorney General and the State Attorneys General, why would you even consider intervening in a matter that relates to an individual Commonwealth public official, High Court Registrar Anna Bennett, for perverting the course of justice and obstructing the people's access into the High Court, when none of you chose to intervene in Rodney's Section 92 or Dr. Beverly's Section 109 matters of the Constitution that are crucial and that is for all Australians. Why didn't you intervene in those matters? Why would you be considering coming in on an individual who's perverting the course of justice? Very interesting stuff going on.
So they're trying to obstruct our access to the courts. And we've also I've heard of cases where the clerk will say to someone, go sit in this room, would you like to work in this room? And they go and work in the room, and then they don't call them for the case, and then the judge rules in absentee. So, there's so many tricks to the book, but I think sometimes people might feel like, oh, this is so far out there. Surely, the justice system is, that this couldn't possibly happen. So I'll get viewers to watch our interview with Dr. Charlie Teo, where he describes his experience with APRA. Now, if you haven't watched it, it basically, APRA was on the evidence of, or on the witness of two neurosurgeons who are much lower status than Charlie, were able to have him put on grounds where he can no longer operate in Australia. Now, Charlie Teo has done 11,000 operations. He has the highest success rate. He is one of the top neurosurgeons in the world. And the charge was that he was overly optimistic when he gave this patient gave consent, based on averages of how badly other neurosurgeons operate. Now, what I found very interesting about Teo's case was that APRA is not actually some sort of court. Like, people sort of think about APRA as though they're some sort of ruling body that has an authority to do this, and they can deregister doctors, and this is what has happened, but they were actually only formed in 2010. And technically, and there's a story that Teo goes into where even the Prime Minister says, oh, I can't help you, Charlie, with this issue. Go talk to Hazard. And Brad Hazard says, oh, I can't talk to you about this. It's a federal matter. So they basically flip-flop. And as it turns out, according to Dr. Teo, nobody, APRA is under no jurisdiction whatsoever. In fact, it's like a private corporation that
It's a statutory corporation.
to put in place. And it's so outrageous because essentially, even like with doctors, let's say doctors have an issue with APRA and they've been deregistered, there's nowhere to go to. There's, like, how can they seek remedy if APRA decides that they're the highest authority here?
Well, they're not. This is the thing that's been very misleading and purposely. And Dr. Valerie Pearce, Dr. Beverly's twin sister, both 80-year-old doctors, she experienced this as have all of the doctors. What the Medical Board of Australia and APRA are telling them, you see, they can deregister the doctor, but there must be an immediate referral to VCAT if you're in Victoria, NCAT if you're in New South Wales. So they were telling the doctors that they needed to appeal to VCAT, and that's how the matter would start. They neglected to tell Dr. Valerie anyhow that she also had the option to go to the Supreme Court for a judicial review on what was going on. They didn't tell her that. So this is the thing. APRA have made the claim. They're not adhering to their own law. APRA must then immediately refer the matter to VCAT, but they weren't doing that. What they were doing was they were telling the doctors they needed to appeal to VCAT. You cannot appeal a matter that's never happened. It's the same principle as if the police charge you with something, the police take you to court. They are the applicant, you are the defendant. This is exactly the same. APRA have accused you of something. They must take the matter to VCAT, and the doctors would have been the defendants. But they flipped it. Everything is totally twisted. Totally twisted.
They're flipping it so that the doctors now have to prove, like, essentially their innocence as opposed to APRA proving their guilt.
Exactly.
And I think we're seeing that too on a broad scale with things like, if people should, I suggest people also watch The People versus Robo-Debt, which is a documentary on SBS on how they were able to fool people with the robo-debt and generate these invoices. So basically, people got an invoice and it said, you owe us $10,000, you've been overpaid. And a lot of people just paid it because they thought, what can I do about this? And they didn't actually investigate or ask the question, is there a basis for this? Can you prove to me how I owe $10,000? So, but with the Centrelink process too, it's also quite interesting because I sort of had a recent case with my daughter where you get to a certain point with Centrelink and they give you the runaround. They don't discuss the law at all. It's all a bit of an illusion, right? And they say, you owe us this much because the data matching system says X, Y, and Z. You explain how they're wrong or they've made an administrative error. No one listens. You go, and then they tell you, oh, best thing to do is go for a review. You go for a review, it takes a couple of years where you finally, get to that review. And then you can appear before the Administrative Review Tribunal and present your case. In my daughter's case, it was like 254 pages of documents. And look, I was able to defend her and we were able to get the case heard and the debt wiped. But it's basically an effort involved into going through the procedure. And I think a lot of people will just go, oh, it's all too much. I'm just going to pay the debt. Because obviously when people receive something like that, they think I must be in the wrong. And I think the same thing is happening with these doctors in their mindset. They feel as though, oh, I did something wrong. No, they didn't actually do anything wrong. In fact, they have rights. APRA has actually violated their rights. and they shouldn't even
Yes.
really exist. But we continue to support this narrative that APRA is this governing body that has
No.
power, no one can touch them.
Hmm.
And so with Valerie's case, what's going to happen now?
Oh my God. Like, if Dr. Valerie's she's been through the courts over 47 times. It's a circus. It is just an absolute circus. Can I just finish with Dr. Beverley?
Yes, yes.
Sorry. So with Dr. Beverley's matter, it has a broader application, because if the states cannot circumvent the Constitution or federal law, pursuant to Clause 5 of the Constitution, can corporations and their policies circumvent the Constitution or federal law? No, of course they can't, because the states have now removed that mandate from the State Health Acts. But it's like this, those mandates are sitting there dormant. They can re-enliven them at any time. So that's why Dr. Beverley is going into, knock it out. So the broader application, as I just said, if the states can't circumvent the Constitution and federal law, corporations certainly can't. And you've still got corporations that have vaccination as a requirement in order to work.
But it's interesting, though, in Victoria, we have the anti-bullying law. So in a lot of ways, the government kind of got these corporations into trouble, because many of them did use bullying and coercive matters to have people vaccinated. So they were like scapegoating them in a way. And then at a certain point in time, they said, oh, by the way, it's now illegal to hold any documentation related to COVID-19 documents. So please go destroy all the evidence.
Keep the evidence. No, keep the evidence, because you told me to collect it, and now you're telling me it's unlawful. It's utter madness. Look, you can also look at Section 5123A of the Constitution, and in particular, after medical and dental services, you will find, excuse me, in brackets where it says, so not as to authorise any form of civil conscription. So they also breached that section of the Constitution as well. But that was argued incorrectly by Tony Nikolic, and Justice Beach Jones made an incorrect decision stating people weren't forced. Now so this is another principle. APRA is a statutory corporation. There is absolutely nothing in the law anywhere that states a qualified medical practitioner must be registered with APRA or with Medicare. There's nothing that enforces that. They don't have to. And one of the reasons for that, I think you would also find under Section 5123A of the Constitution, because that would be a form of civil conscription if they were being forced to register with APRA. So it's all just, yeah. Well,
mandates still exist here in Victoria. They do, not just in some private workplaces. I'm not sure whether in New South Wales they did pass the law that said that employers were going to be fully liable for any harm that happened to employees if there was any mandates. So this is really a strange thing, isn't it? The government says to the employers, you must mandate, but then we're going to put this extra law in place that if you do mandate and someone gets injured, we're not going to cover the cost. We're going to put the cost on you.
It's madness. We're forcing you to do something. It's crazy.
And then the compensation, C19 compensation, through Centrelink, the government compensation is closed. I think it was September last year. They closed it as though, and there was some record number, I think it was 200,000 or more. That's not even the ones that were registered into the TGA database. It's not like there was any automated system. It was very difficult for people to firstly report. It was very tricky. So one of the qualifications to get compensation, I guess, was just spend a night in hospital, right? And so people would report post-jab to the hospital to try and get a vaccinate, to try and get some help. And most of the time they should have said, okay, you need to stay because you've got myocarditis or whatever. But in the end, they just send them home with aspirin. Person would go home, or even worse, they would say, I think it's psychological, it's in your mind. Referred them for 10 health checks or whatever, and said to them, get your GP to give you 5 subsidized health checks. You know, but the thing was, because of that, a lot of people didn't actually have the paperwork there to say, oh, I reported 3 days after or 2 days after.
Yeah.
And they were just saying, oh, well, we went to hospital, but it was just a headache or something. You know, there was nothing in paper. And then they obviously made things very difficult. And then there were certain things where if you, it had to be reportable to that particular vaccine. So if it was AstraZeneca, you could claim certain conditions as though it was all known, not that it was anything. And it certainly wasn't sold to the public that way, that if anything went wrong with this experiment, that the government will look after you. And now they've basically closed it all off and said no. And I actually wonder, I do wonder what actually happened to people who did get vaccinated. What were the consent papers that they actually signed for it? And I've never ever seen any consent papers. And also, whether if they did accept the compensation, whether they were no longer able to civilly sue anyone for harm or damages. So, and I know there's probably been lots of out-of-court settlements that we don't hear about because everything's always sealed under.
Or they just swept them under the carpet and made the court dates that far in advance that they may not be around anymore. See, that was the other thing, my understanding, because obviously you would too. We know a lot of vaccine-injured people, but they then had to prove that they did not have any underlying medical conditions that weren't underlying. So unless you could prove that, and then they'd say, oh, well, we don't know that it didn't exist already and you might have come down with that anyhow. There was, like, it's a mad, mad world, but the bottom line is they can't force anybody. And you look at the other side of things, the doctors must first and foremost, if they are going to offer a medical service, they must also give the option not to accept the medical service. Now, if they're offering a medical service, they must provide you with full disclosure of the side effects or anything that may, occur as a result of that medical service. So the thing then is, so in law, you must provide not just consent, it must be informed consent. And that was absolutely impossible because AHPRA threatened doctors with deregistration if they spoke the truth. It's utter madness. It's hard to understand or comprehend, I should say.
Yes,
what
and
a
also
twisted world we're in.
I would make the argument that no one could make an informed consent
No, they couldn't.
when
There
they
was
were
no
under
information.
such duress as that.
And
They
it's an
couldn't go into.
experiment.
And I think we also would like to touch on the closed borders thing. Like you were saying how for that time that Australia was closed, we weren't actually a Commonwealth, or I think that's what you said.
Yeah, well, so this is what Rod Culleton's presenting. So Dr. Beverley's doing the right to bodily autonomy and stopping the ability of the states to ever use mandation of a medical service as a requirement to work, because that's how they captured everyone. They threatened them with loss of livelihood. You're going to lose your house. You won't be able to feed your family. Like, that just threw people into extreme anxiety and stress.
And this is what I want to stop you here and to say to the audience is that these aren't just individual cases where people are fighting for their individual compensation. What's happening here is we're looking at cases which is trying to overturn the law or to repeal these laws. Isn't that what we're suggesting here? So that they can't use these again.
Correct.
Whereas there has been, in my knowledge, private settlements here and there.
Yeah.
And none of those have set any precedent. Firstly, they don't get into the courts. But even if they did, I think that it's just an individual case. It doesn't actually overturn because it's not heard in the right court. Yeah. Is that what you're saying?
Well, yes and no. This is the thing that I find extremely frustrating is those that are putting themselves up on pedestals and going into the court and asking the Australian people to fund them in their own private individual matters that will have, they'll have no effect on Australians. Every single case we are doing is for all Australians. There is nothing individual. This is for all of us. So Dr. Beverley is fighting for all Australians. So never again will they be able to force or make vaccination a requirement to work. And as I said, the broader implication with that matter is if corporations can't do that with their policies, you then have to start looking at, well, what exactly is a trading corporation or foreign trading corporation within the meaning of Section 5120? Would the Education Department fit that? Yes, they would. So that would then stop the ability of them to make our children get vaccinated to go to daycare, through school or in university. Like, this is absolutely criminal what's going on. So Rod's matter. Rod is standing up for all Australians doing a Section 92. And Section 92 is where travel must be absolutely free. Trade, commerce and intercourse must be absolutely free across all of the boundaries, internal boundaries. So Clive Palmer's matter, in my opinion, was designed to fail. It was not a constitutional matter. It was very timely heard, where the borders of WA at that time had not been shut for a period of more than a couple of months. So Western Australia had their borders closed for 2 years, which that actually meant that Australia was no longer Australia. We were no longer federated. So Dr. Coburn in the Sydney debates made it very clear, and it's been repeated throughout High Court case law, that the quarantine power cannot transcend that of trade and commerce. So trade and commerce must always win out. So for to do so would be something that the Constitution forbids. So Rod is challenging the ability of the states to shut the borders at all. Now, you can understand, of course, in a state of emergency, if you've got a bushfire on the border, for safety, they'll close the border and go, no, there's a raging bushfire here, you can't drive into it. But quarantine is a different kettle of fish altogether. And you've got to look at the Biosecurity Act, the federal act that covers quarantine, and then the quarantine powers that you used within the state acts all had the same requirements that once again they are not adhering to their own laws, because both the state and federal acts stated if you are to be quarantined, you would have been handed as an individual a piece of paper after being examined by a medical practitioner that would list the disease that you had and the length of time you had to be quarantined. You cannot arbitrarily shut down entire states or regions, and it's exactly what they did. So the boundaries within our nation are, the only reason they are there is to give the geographical location of each state's legislation's jurisdiction. We can travel across our nation freely, unhindered, in our personal and private capacity. I mean, Gratwick versus Johnson was a case, I think it was 1945 or 1946, but it was in times of war. Yeah. And even in that case, it says, no, they cannot shut down these boundaries, and the Constitution cannot be suspended, even temporarily, in times of war, in times of emergency. So Rod is challenging and trying to invalidate sections of the Emergency Management Act of WA, which is their version of the Health Act, And he's also challenging the ability of the states to have this rollover power, so they can just roll over quarantine for 1 month, 1 year, 2 years. Like, that is absolutely unconstitutional. He's also got a third challenge, which is the courts have been using what's called the McCloy test. It's a proportionality test where, so this is the courts, the judicial side of the separation of powers is sitting back and saying, oh, look, is that act or is that law fair? Is it reasonable? That is none of your business. That is actually ultra vires the court, because the only ones that are to be concerned with whether an act is fair or reasonable is the legislature, the legislative branch of government. The court, the judicial branch, their only concern and only role is to determine, is that act constitutional or is it lawful? So Rod is challenging that. What he's doing is a collateral attack on the Palmer matter in WA. It was argued incorrectly. And you can't tell me that Clive Palmer's QC, Mr. Dunning, didn't know what he was doing, because he did not even challenge the validity of the Emergency Management Act. All he did was challenge the directions of the CHO. Like, it's an absolute joke. You can even find, if anyone wants to go and have a look at the case, in the transcript, Chief Justice Kiefel asks him 3 times, Mr. Dunning, are you challenging the validity of the Emergency Management Act? 3 times he answers no. She says in that transcript, well, Mr. Dunning, we don't have a constitutional matter. And that is because the restraint of the Constitution operates upon the legislative authority, which is the Act, not upon the directions of chief health officers, someone of an executive office. And I've got that, that is read in, that is in High Court case law. Like, it is absolutely, here we go. So this is Chief Justice Latham in MacArthur versus Brodie, High Court of Australia. There is no authority for the proposition that the courts are authorised to inquire whether such restrictions are reasonable or not in order to determine whether they become burdens, so as to infringe Section 92. It is not for a court to determine whether it's reasonable or not. And then it's got, once again here, but it may convey the impression that the law itself must be reasonable. And it is no part of this court's function. Sorry, so this is from Justice Dawson in Nationwide News, this quote that I'm doing now. And it is no part of this court's function, once a law can be seen to be upon a subject matter confided to the Parliament, to determine whether in its view the law is reasonable or not. That is a matter for Parliament and not the court. So everything I say, this is not my opinion. I am telling you, or trying to convey to people, this is High Court case law that has determined all of this. I'm not saying it. The justices of the High Court, and I mean, I've just read out 2, for example, on that matter. There's probably 30 principles. There's also a lot of High Court case law on the restraint of the Constitution operates upon the legislative authority and not executive orders. Yet we saw a replication of that from Palmer to Cottrell versus Romanis and Kazam versus Hazard.
Yeah,
they were not
you're
constitutional
saying that
matters.
they put the wrong defendant. Some of the tactics might be they use the wrong defendant, they put it in the wrong court, they make the wrong case argument. And I think a lot of people don't take the time into actually looking into the court documents after the fact and realize that there's a lot of things where, you know, the so-called lawyers there who are supposed to do their job don't even submit documents that they were supposed to and asked by the court.
They won't go against the state, Jenny. They will not go against the state. They'll lose. This is why you don't want to have anything to do with them. They're all crooked and they're all corrupt. So I'll also read you, okay, so back to Dr. Beverley's High Court case law. So this is in what's called the Outback ballooning case. So this is to determine whether inconsistency of laws between federal and state. The first approach has regard to when a state law would alter, impair or detract from the operation of a Commonwealth law. This is referred to as a direct inconsistency. So if a state law is in conflict with a Commonwealth law and the state law in its operation and effect would undermine the Commonwealth law, that is a direct inconsistency. The second approach is if the Commonwealth has written a law which expresses an intention of this kind is said to cover the field or cover the subject matter, or for these purposes, it is to the exclusion of any state law, then a Commonwealth law of this kind leaves no room for the operation of a state or territory law dealing with the same subject matter, and there can be no question of those laws having a concurrent operation within the Commonwealth law. I could read you out 20 more cases, but this is all very well established High Court case law, and that's how these cases, the authority relied upon within the arguments is all based on High Court case law that the justices of the High Court themselves have relied upon for decades.
Yes. So the real goal here is to get things into the High Court if possible. And I think even when you're looking at things like no jab, no pay, I find it interesting with that it really affected, what do I say, poor people more. For example, the incentive to, because they were going to lose the subsidy, right? So in a lot of ways, and of course, you know, if you're really wealthy, you could just have your own nanny. They didn't actually pass any mandates and say, oh, by the way, you cannot nanny or look after children that.
But no jab, no pay. Correct me if I'm wrong, Jenny. That pertained to an incentive to have a tax cut. It wasn't that you couldn't work. It was.
Oh no, I'm talking about the no jab, no pay in regards to childhood vaccination. So in around Scott Morrison and all that, they brought it in. This is where I guess the whole anti-vaccination movement came in. This was the precursor to the mandates that we saw in 2021. So they started off with the children. It was like a little experiment. How far can we push this? And in fact, way back then, I think it was like 2017 it first started, they were deregistering doctors. So initially what happened was you could get an exemption, a religious or conscientious objection, and there was no problems. You were just treated like anybody else. It was your personal right to vaccinate or not vaccinate your children. In fact, that really only came into play probably around maybe 15 years ago. They brought into some sort of benefit. It might have been a maternity supplement or something like that. So they got people used to the idea that if you want this payment, you're going to have to go to the doctor and get a conscientious objection. And then but in essence, they should never have compelled anyone. It was always before that, like let's say 30 years ago, if you chose not to vaccinate your children, it was no big deal. It would just be like, oh, you don't want to take penicillin, you don't want to take Panadol. And then they started off with the whole herd theory, and then they populated that idea into the public that somehow if you weren't vaccinated and you didn't have any disease, you're going to be a risk to people who did choose to vaccinate, even though the vaccine was supposed to protect them from this plague and then of course they put up some 95%, you know. So this is how they kind of played it. So with the no jab, no pay, what they've done is they've not actually said to parents, like in Singapore, this is where I talked to Iris Co. They've passed a law, maybe their constitution is different, that they're fining parents for not vaccinating their children, right? $10,000. Now, of course, if you've got more than $10,000 and you're ultra wealthy, there's an option there. You just pay the fine. Okay, so it doesn't actually affect the super wealthy. They can just pay the fine. They can go to school and do their usual thing. But it's in a similar way, the no jab, no pay, they didn't put it in such a way that was going to discriminate against anyone that had any money, that would say, fight it in court and take it to court, right? Because they don't really want people in the courts like you're doing right now to fight the system, because that would, and especially not in a way that will overturn the actual legislation and repeal it.
Yes.
That is the end
Yes.
goal of it all. We need to repeal it.
Yeah.
So I know that who was it? Senator Antic has put in some legislation. He wants to put in an act to basically reinstate the conscientious objection to the no job, no pay. But it doesn't actually.
Why doesn't he attack the act?
Yeah, he
This is
doesn't.
the
And
thing.
apparently, look, I talked to another senator who I can't remember the name of. He ended up losing his seat, the seat of Monash. Let me remember his name later. He received thousands of messages. Russell Broadbent, yeah, sorry, that's right. He received thousands of messages from parents who were affected by the no jab, no pay when it first came in. I mean, these are parents who went and vaccinated their kids, and they're often put on a accelerated schedule because they missed so many, and they got injured, heartbreaking. And also the ones that just took one and got damaged and injured. And so and of course killed, or, SIDS or whatever.
Autism, etc.
So he received so many heartbreaking letters. This is before he lost his seat. And I did have a conversation with him about this, and he felt that the public weren't ready to, have this law repealed. And this is the thing, isn't it? Is that we're saying, okay, we can put in these illegal measures that go against the Constitution, the carrot and stick method. It's not right. It's not moral. It's coercion. But we're going
to goes against contract law. It goes against contract law.
To this whole bullying act, because the public just love it when the nanny state comes down and says you must not wear something or do something. I mean, what next? I mean, what will they say? Will the government make a rule as to what women will wear? Well, are they going to legislate that? Are they going to say no more tattoos? Or, how far, what is the line that people are willing to accept as tyranny? And I feel as though since COVID, the line just moved. People are far more willing to accept things.
It's indoctrination, isn't it? It's like shortening the chain of a dog link by link, and you don't realise you're in a chokehold. What they're doing now is they are militarising the health system. With what's going on and the way we're going, they're going to be able to point you out and say, right, you hand over one of your kidneys. Or we want your children's livers. This is never going to stop, and people don't recognise this.
Well, I think there was a move to make an opt-out of the...
We've got to get it. They cannot be making these laws. They go against natural law. They go against the Constitution. They go against contract law. But people... Look, we can't expect people to sit back and study law, can we?
No,
but they need to have faith that the Constitution protects them. Yes. Will protect them. It is a restraint on government. People need to recognise government are our servant, and they need to be put back in their place. And really what they're doing with all of this business with, I'll give you an example. So in the Biosecurity Act, it's section 478 and 479 of the Biosecurity Act. That is where you will find WHO recommendations. Well, I'm sorry, but the Constitution gives legislative lawmaking powers to Commonwealth and state parliaments, nothing else, and certainly not a foreign power. Because if you have any just acknowledgement of allegiance, adherence to a foreign power, that would mean disqualification and attainted of treason. Yet now we've got them signing up to the bloody World Health Organization. Like, we can see this unfolding. Why on earth would you sign up? I'll tell you something else. Treaties can only be entered into between two or more nations.
Oh, right.
The Commonwealth cannot enter into a treaty with a private World Health Organization. I'm sorry, you're not a nation. You're a foreign power.
And we never really needed to fight that in the first place because it was never legally binding in the first place. But a lot of energy was put into this idea that stop the WHO, stop Australia signing this
Well, they signed the
legislation.
treaty. They signed
Yeah,
it.
yeah, but
So this
I
is the
mean,
thing. They're getting ready. What they're doing now, we're not going to feel the effects for another 10 years.
and the biosecurity laws have been weaponized against farmers in particular. And then you're seeing what's happening in Victoria with them coming to the farm gate and trying to put in these transmission lines and the farmers standing their ground and saying no. I think we had Trevor Hold talk about, I don't know if you've heard about it, but the fire ant baiting, where they just basically spray the whole thing with pesticide, like these baits and pesticide. But the
Poisoning.
crazy thing is, it's like with COVID, it didn't matter that you were sick at all, like had any symptoms whatsoever, you were locked in quarantine. It didn't matter that whatever arbitrary decision the government made, your business had to close if they decreed so. And now with the Biosecurity Act, they're coming along to people's private properties and there's no sign of any disease or even around the place. And they're saying, oh no, we need to spray the whole thing.
No, they need to provide evidence. This is the thing. They must provide evidence. In reality, the Biosecurity Act really only pertains to the external borders.
Yes, yes.
So look, we've got cases, Jenny. We need people to put their hands up to bring matters into the High Court. And we need Australians to all get behind this and support them. It's absolutely transparent, this case. We've got the 4 live matters at the moment. So get behind Rod Culleton, he's for our movement. Dr. Beverly Pearce is for bodily autonomy. Dr. Valerie is fighting APRA, and that is going to go places as well. And then we've got the online safety case, which the federal court hasn't responded yet 5 weeks later.
Yes.
So they're
And you've got
trying
a
to
risk,
keep us out of the court.
there. And I read of the writ, and it's quite interesting what you're actually saying. It's like an overreach, yeah. Like this is what we're actually
Absolutely.
experiencing.
This is
That the
all absolute
Constitution
overreach.
protects our rights, and the government is basically saying we want more and more and more. So you're totally controlled. You won't be able to eat tomorrow because we'll decide what you can and can't eat and how much, which they may just well do with the whole carbon credits, right? Like they may say, look here. I mean, how much are people willing to accept? Here's your carbon
It just
credits.
gets more and more ridiculous, seriously.
And they do, they keep on adding more and more layers to this. But it's interesting how far they've been able to push this and how much we are willing to accept. And I think Australians are possibly at a tipping point. Maybe the under 16 ban will wake a few people up to say, well, hang on a minute, they're our children. And now
It's none of your business, government.
yeah,
None of your business. Get your noses out of our private lives.
yeah. And we do know, like in the hospital system, there's a lot of people who have suffered at the hands of the medical system when their children go into the system, and then they suddenly realise that their rights as parents, they don't have them because they can weaponise child protection against them, the medical system against them, and they can't get the help that they need within that system. I think
yeah.
Sarah's Last Wish is a good book that I always ask people to read. It's a case of a girl who had terminal cancer, and she was forcibly separated from her parents because parents wanted to try a natural approach. And she died, but they ended up experimenting on her in various ways. And that it's unconscionable what has happened. They wouldn't even let her, they break up the family, and then we've got this case.
That's
I
the
think it's very
idea.
interesting with Celine versus the machine with e-safety commission, and where I feel like, so I made a post about it the other day. I was quite surprised. Normally on Facebook, I'm quite, censored. I'm censored everywhere at the moment. I'm censored on LinkedIn. But this particular post went to like 63,000 views. And I feel like there was a lot of interest in this particular case because Celine had made a post about it wasn't grooming. What was it called again? It was a queer club. Yes, a queer club for grade 3 students, so 8-year-old students in a primary school. I think it was Hurstville Primary School. And it was taken down by the e-safety commissioner. So she, with the help of the Free Speech Union, took it to the Administrative Review Tribunal, and they said, well, no, it was overreach. They don't have the power. The e-safety commissioner doesn't have the power to rule in this case. You need to, you can't do this. And now the e-safety commissioner has decided that she's going to take it. It was today. I'm not sure what the verdict was. They're taking it to the courts today. I think it's the Supreme Court. Not
We
sure.
were trying to reach out and join up with her.
Yeah, it was a bit, I guess everything was quite late, but
Yes.
it's interesting that this case in particular, I think, is a very special case because it just shows you that the e-safety commissioner is about safety of children. That's what they're arguing in regards to the under 16.
And everything they do is the opposite.
Yes, and this one is very much exposes how crazy it is. Like, so Celine's writing a post about just telling people that there is this queer club that they're likening to a Lego club at a grade 3 level, which,
well, it's sexual. It's sexual.
yes,
Why
yes.
would they be like, that's inappropriate? That's X-rated, R-rated. Since when is that acceptable for our children?
And you couldn't put this in the workplace. A lot of the things that are happening in schools today and the things that they're discussing, chest binding, all sorts of really crazy stuff, they couldn't put it into a workplace educational thing because that would be, not right and
Not appropriate.
not appropriate, sexual harassment or whatever. But they can put these things in schools. Now, I think this case is very interesting because it just exposes how far the government is willing to go. And one of the things was that the public servants or whoever was working for the e-safety commissioner, it was out of scope. They were just making decisions without actually consulting the law. And in fact, whether the law is legal in the first place has to go to the High Court to decide. But it's very similar to what you're saying here with these various administrators sort of blocking your access to the courts.
Yes.
And so why are they blocking our access to the courts? Because that's where we can get remedy.
Yes, that's right. Because the whole show will come falling down around them. Once they can't mandate vaccination, once they once again recognise it is the doctor-patient relationship is a contract law, and basically our health is our business and our children, our most precious asset, are our business. We take care of our children and make decisions on their behalf. And what the government is doing is exposing them to absolutely debauchery. It's insanity. You look at the online safety. They cannot control the end user. Listen here, government, if you're concerned about bullying, there's the Crimes Act.
Yes.
Those people who are bullying will be charged under the Crimes Act. If you are concerned about debauched, inappropriate material, go after those that are creating that material.
Yes.
Maybe the service providers should be looking at if something's totally warped and sick and not allowing it onto their platform. But they cannot stop us. And this is what it's all about. We basically have the government I call them the sovereign seas, because they are the ones that are sitting back inflicting violence on the people. They do not think that the law applies to them. And they are terrorising everybody. Australians with the COVID, absent any facts in evidence. They are terrorising our children about that. And climate change with no facts in evidence. They say something, they're terrorising people. Always continually putting fear into people. That's how they get the control.
Just things as basic as speeding fines. It's crazy the number of roads here that they keep reducing the road limits to. And of course, say you've been on a road, it's always been 70 all your life. All of a sudden, out of the blue, it's 40, but not all the time, only at certain times of day. And then it makes them millions of dollars. So they have no justification for it all. We actually had a 70 road that we are on. Suddenly one day just changed to a 60, and they've only got one sign which is right at the end near towards the beach. So no
They're
one
doing
will
it
be
everywhere,
saying
aren't they?
changed road. And this road has been 70 for, you know, decades, okay? And all of a sudden it's now 60. Now, what is the fine for over 10 Ks? You know, a few $100, you know, demerit points, loss of license. But all of these things are adding up to people as, well, is it fair? Is it right?
No.
I mean, we all can agree, okay, there has to be a way to stop people from
We've
doing the
got a
wrong
case
thing.
for it, Jenny. We've got cases written to address nearly all of our issues. We need plaintiffs. You know,
Right.
you've got the other thing as well. So, Fines Victoria. Are you a trading or foreign trading corporation within the meaning of Section 5120 of the Constitution? Are you a court, Fines Victoria? Because you can't issue fines, only a court can. There are so many arguments. We are stuck in this corporate world. They've created all of these corporations. And, you know, then you've got a question. Where's all that money going? Who owns Fines Victoria? Who owns the toll roads? Etc., etc. Where are our taxes going? Where's all the stamp duty that we pay on houses or, you know, change over for cars? Where's our rates going? Excuse me, are these organisations not all trading or foreign trading corporations? Who actually owns you? What foreign entity? And where is our money going? Where is the Consolidated Revenue Fund? Where is all the money from our equity and wealth, all of our resources, our water, our land, our air, our minerals, etc.? Where's all that going? This government is bankrupting us and they are in allegiance with foreign powers. They have sold the Australian people out. They are meant to be operating as trustees of the Commonwealth for us, the people being the sovereign beneficiaries of this nation. The people are the Commonwealth. And we are.
I don't think people sort of can conceptualize how bad it is
Because
they're
they've been
not
brainwashed.
coming,
Yeah.
it's not just a fine here or a fine there or, you know, jump through this, people that. They actually want it all. You know, like the fact that the ABS now doesn't actually report excess data properly. And they fudge the books and they can just create some $96 million, you know, Bureau of Meteorology website that no longer works properly, and people can just accept that and say, hey, that's okay. Who at 96? How can a website be $96 million? Where did all of that go? The level of corruption is on such an incredible scale, and we were quite happy for that corruption until it didn't even stop there. You know, like this corruption's obviously been going on for a long time, but it went on
Where
to
does it
like,
stop?
okay, how much more money can we make? We need to do all these things like mandates, because there was no way that they were ever going to get that injection into people unless they mandated. Because when I was looking at the uptake initially, it was very slow. Like it was going to take like 30 years for anyone
Until
to
they
take it.
threatened loss of livelihood.
Yes.
They threatened loss of livelihood. That did it. They forced everyone. They terrorised Australians. If you don't take this experimental vaccine, you're going to lose your job.
Yeah.
You're going to lose your house. You're not going to be able to feed your family. You're going to end up on the street. That's terrorism.
Yeah.
It's unconscionable. It's malfeasance.
It
You
is.
know, and you've got to think of all the bullshit they tried to bring in. They were trying to bring in the misinformation and disinformation bill. Hold on a minute. Who's guilty of that? Government. It's safe and effective. And if you don't get it, it doesn't matter, in the middle of nowhere, it'll track you down and get you. Like it's an IQ test and it's a tolerance test, and it's people need to stand up. United we stand, and this is why they keep bringing in race against race, religion against religion. Yet all that rubbish with the blooming Muslims and Christians. Like, what a load of rubbish, and how many idiots fell for that. Oh, these Muslims, look what they're doing. Forget it. Throughout history, for thousands of years, that's how they have controlled the people, turned them on each other for their differences. instead of us, you know, really recognizing that humanity is one. We're all made from the same earth, ashes to ashes, dust to dust, as it goes. We are all one. Humanity is under attack, and we must all link arms together as brothers and sisters and stand up lawfully and peacefully always.
So where can we, is there anything you wanted to add before I wrap it up with where the people can find more information, and how they can support the various cases that are going ahead?
I'll give you the bank account details for donations, which would be greatly appreciated. And if anybody is interested in being a plaintiff, the cases are written. The writs are only about 12 pages long, and you will be tutored. You'll learn it. You can read the cases, read the high court case law, which is where the authority of the arguments, that's the authority relied upon, is what the High Court has determined, due process of law. So you will be there with you holding your hand for the whole time, basically,
Yes.
as lay people.
And you've got a website. You're on Facebook, Instagram. You've got a constitutionalwatch.com.au. Is that right?
Constitutionwatch.com.au is Darren Dixon. He has created the most informative site. Everything is factual. You'll see the convention debates there. You'll see the Senate estimates. You'll see all the FOIs, all about legislation, statutes, etc. He will go through all, you'll see the anomalies, etc. So it is the only website in Australia that I would recommend. And the only group I would recommend is Know Your Rights Group. That's it. And Commonwealth custodians. I am a Commonwealth national. I've gone over with the Commonwealth custodians. Keith Charles is an amazing man. He served the trust deed and declaration on government. We are strong constitutionalists, peacefully and lawfully, and it's filled with scripture and maxims of law. The people need to take back the Commonwealth. We are the sovereign beneficiaries. This government has forfeited their role, and it is up to us for them. Well, I've started my paperwork. I've reached the age of majority. It's a shame that this world operates on illusion and assumption. And they assume that when you turn 18, unless you advise them you've reached the age of majority, you're still an infant and they'll treat you as such, which is why we've got these issues in the country, which is why the UN are the executors and trustees. Because Australians, we have not stood up yet and said, you know what, we've reached the age of majority, we're going to take care of things ourselves. So yes. I cannot encourage people enough. I'm going through the whole process. I've gone backwards and, over and over this with Keith, and it is flawless as far as, everything is absolutely by the book. So commonwealthcustodians.org. And we've got a seminar on the 14th of December. Can I send that to you so you can put it up?
So we're going to just put all the important files, links, contact details, everything on our website, Health Alliance.
That would be amazing.
And if you want, it'll just be like, we will, look, I'm not sure we'll be able to get this onto YouTube, but I don't even think it's worthwhile. YouTube is so censored at the moment. It literally is non-existent for us. Rumble, YouTube, we're on LinkedIn, which seems to still be kind of working. And actually, what was it? I keep forgetting what it was. That other platform that I hardly use, TikTok, that's right. TikTok is actually been quite good for me. Surprisingly, it seems to be the only one that allows, if you get a quality post on TikTok, it can go viral regardless of how many followers you have. And it doesn't seem to matter anymore how many followers people have. I've seen channels with millions of people view and subscribed, and they literally get only 1,000 here, 2,000 views. You think, how could this even be possible? What's the point? Why are people built all these platforms only for these oligarchs to control? And this is what we're seeing. We're seeing a merger of tech and government, which is essentially the same. Because you look at the e-safety commissioner, she worked for she worked for Microsoft, I believe, and all these other tech giants. You know, I think she worked for X as well. So it's very interesting, the merger of these big tech companies and the government together. They act as though they're having this war right between them. But they're not.
But they're not really.
They're
no,
not.
no.
So because
They're
if they
all in
did have a
together.
law, where is the court case that supposedly Musk was going to file against the government? You know, where are all these tech companies coming to the defense of the Australian people? But no, they're all going to roll over and say, oh, we're going to ban the under 16s from social media so that they can get people's ID. Now, here's where it's all going to fall apart, is they're not going to be able to keep any of those details secure, or the biometrics or anything. And then it'll be like, oops, we just lost a million credit cards. We just lost all your details and your ID. And then you have, you know, all sorts of identity fraud left, right, and centre.
Yeah, your money from your bank account's gone. We've lost your house titles. You own nothing anymore. Someone told me that Elon Musk had actually put out an offer to fund anybody fighting for freedom of speech. So I did a video. Like, I will say, do I trust him? No. But I thought, well, why not? So I went, okay, Elon, I've heard that you are offering this. Basically said, well, I'm going to take you up on your offer. We've got the cases written and we need funding. Here's the bank account. I got slammed. All these people, well, not maybe a tenth of the comments on there. Oh, they're satanic. You should know that. You're an idiot. It's like, as if I don't know what I'm doing. He's put an offer out. I'm not offering anything other than to take the money to fund the cases for the benefits of all Australians, because that's what we need. We need the money to get these cases over the line.
So, you know, so while they're pretending that they're going to fine these companies $50 million for breach, right? And of these companies, if they were really concerned and really believed that the Australian government was going to fine them $50 million per breach, right, which could send them broke, they would actually be in court right now, because even one fine is worth $50 million to them. But where are they? They're nowhere to be found. So it's up to people to understand what's going on here. Don't hand it over. Simply just don't comply.
That's it, exactly. You see, what needs to happen is these platforms need to they need to take that challenge. You show us where is the traceable source of legislative authority for you to put the onus on us to check our end user's identity. There is none. You've got no authority to do it.
Yes.
It's insane. So can I just go over commonwealthcustodians.org? Please, all Australians, come back into the Commonwealth. We've got the electoral roll running. We've got stewards. We need people with organisational skills, because we're taking back the country and we need to have the positions and roles in government filled by us, the people. So put down what your skills are, and everything will, it's all under the Constitution, no political parties. Look up Know Your Rights. They do seminars in different states. Darren Dixon's constitutionwatch.com.au. And if you are interested in being a plaintiff, please email Darryl O'Brien, and his email is info@knowyourrightsgroup.com.au. And I'll send all that through to you, Jen.
Yeah, and do keep us in touch about what's happening with these court cases, because I think it's very. I'll try and put the links to them and information there as well, so people can keep a watch on that, because I think what's happened here is that we've become quite distracted here and there with whatever is going on.
That's the plan.
To have a remedy here, because we are still under some sort of, I think people are probably a bit shell-shocked. I think that's what we are.
There's too much going on.
There's so much going on. But in closing, I did want to remind viewers to check out our other podcasts, which feature leading medical researchers, but also lots of testimonials about healing from various things that were previously thought terminal and incurable by the medical system. So we try and put a lot of hope out there as well for people that, you can take, just like you can take your health back into your own hands, you can take now the law side into your own hands. So in this particular podcast, the actual other podcasts that relate to this one in particular are Dr. Charlie Teo, Jemima Toby, Iris Coe, and Trevor Holt. And all of these people have essentially fought the beast, fought the system to varying degree of success. Jemima Toby was a very successful one. Iris Coe is hitting goals out in Singapore. She's also got a book out now. Trevor Holt is holding his ground, doing the fire ants thing. And there's lots of other people that I haven't mentioned in Australia who are all, fighting the good fight on the ground, grassroots movement here. So it's not that you're alone. I think it's just once you start looking, you'll see that there's a lot of people standing up for themselves and they're actually winning. And you don't see the wins as well. I think in the public sphere, we're not hearing about the wins. But that's why I put Jemima Toby's story out there and the level that she went to fight the system, keep her business open. I think that's what we didn't touch on here too, was that how wrong it is that the government can shut business down arbitrarily. Your way of making an income, that they can come with the force of the police to shut your business down. And if Australians don't understand that, they could still do that tomorrow. What happened in 2020 and 2021.
Do not comply.
Yeah.
Band together. They've gone beyond their authority. Oh, the next court case in New South Wales Supreme Court, 15th of December.
Okay.
We had 90 there in the courtroom the first time. Let's double those numbers. The court didn't know what hit them. Oh,
great. So anyway, send me those details. I'll publish it.
Thank you. Thank you so much for having me on today.
That's great. So anyway, you can also subscribe to our mailing list, distribute this to as many people as you can. We don't expect the algorithm to work in our favor. And thank you everyone for watching. Thank you, Jackie, for your time today.
Thank you.